Yes, good evening to the participants of the JCJ 2022 main examination. And yesterday I dealt about the attachment of the property of the CPC, and today is the same continuation class. Anyone can unmute and read what I posted on the screen. Participants, anyone can unmute and read what I posted on the screen.
Properties liable to be attached, section 60.
Yes, continue.
All conceivable movable and immovable properties such as lands, buildings, houses, goods, money, bank accounts, government, securities, bonds, corporate shares, salaries, rents, etc. held by judgment debtor or someone else on his behalf.
Yes. This is between the plaintiff and the defendant, and especially the civil suits. And there, even the motor vehicle accident also comes over there. And they are clearly mentioned the houses, buildings, lands, goods, money, bank accounts, government securities, bonds, corporate shares, salaries, rents, etc. These are all the properties which can be attached. That we will see now. And in yesterday class, we dealt up to this extent. And here I put the asterisk mark, which I shown over here. Now I'll remove it. Up to that extent, we dealt it yesterday. Now let us see in this class, property that cannot be attached. I repeat, the property cannot be attached. So some kinds of the property that cannot be attached and sold in the execution of a decree, and which is expressly mentioned here, execution of a decree, it is, better we'll make it, it is expressly mentioned in the section 60 of the Code of Civil Procedure. So which section says property cannot be attached? Section? Section? Say. Participants.
60, sir.
60. Why you are taking so much time? It will be there on the screen. I want to see whether you are present or not. And everybody should have to take part in the my deliberation or online class. Okay. Particularly like wearing apparels, cooking vessels, beds, tools of artisans, books of accounts, any right of personal service, wife and children, stipends and gratuities allowed to pensioners of the government, etc., and many more. What these are? Can be attached, cannot be attached.
Cannot be attached.
It is cannot be attached. Wearing apparels means
Cloths.
it's a dresses, dress materials, pant, shirt, trouser, etc., etc., undergarments. Cooking vessels means
The utensils are used for the purpose of kitchen, sir.
for the kitchen where you are cook, either the rice or curry or whatever it may be, such vessels. What is the next synonym for the vessels?
Utensils, sir.
Yes?
Utensils.
Utensils. Good, I appreciate. Beds. Here bed means either two-bedroom, double bed cot or single bed cot or folding bed cot, whatever it may be, the beds. Tools of artisans. What is maybe tools of artisans?
The things which are used for the purpose of his livelihood, sir, like
Here the artisans means either the agriculturist or the skilled people also.
yes, sir.
Suppose if it is agriculture, then what are the tools that you use, a farmer?
Tractor.
Of course, now he is having the tractor. Before that,
Cows.
plow,
Bullock cart.
bullock cart, bullocks, and sickle, hammer, which will be used over there in the cropping. So books of accounts, here the account books, ledgers, etc. Any right of personal services Suppose if he's a painter, you cannot seize his paint or brush. Wife and children, you cannot mortgage the wife or the pawn the wife and children. You cannot attach them. Am I right?
Yes, sir.
And stipends, scholarships, and gratuities. Suppose if you work for there and you will be given the gratuity. Generally, 2 years gratuity is 3 months salary. And gratuity is allowed to pensioners of the government, etc., and many more. These are the things which cannot be attached. Now let us see what is the mode of attachment. Anyone can unmute and read? New persons, I would like to see. New persons. Arshia, read this which I highlighted.
Yes, sir. Rule 43 to Rule 54 of Order 21 lays down a proper procedure for attachment of movable and immovable property.
There is something wrong, is there? Could you tell me?
For is there, sir. She read as 2.
Okay, well, that is one of the mistake. But some here there is something wrong, is there? Can you tell me? Yes, if you don't know, you say pass on.
Yes, sir. Yes, sir. Rules. Yes, has to be there, sir.
Sometimes they say rule 43 means singular to rule 54. So when you say rules 43, 44, 45, 46, order, you are not supposed to write in.
Like
You are not supposed to write in Arabic numerals. How it should be written?
Roman letters, sir.
Roman capital. Is it correct or not?
Yes, sir.
This is the style of writing. 10, this is 12. Total 22. Am I right?
Order 21, sir.
Is it order 21? Okay. Okay, order 21 now. Is it right?
Yes, sir.
So order 21 lays down a proper procedure for attachment for the movable and immobile property. Both the thing. And here order 21, rule 54. See here he wrote correctly. You are right.
Yes, sir.
See, Professor Hussain's students should have to know what to write and what not to write also. So order 21, rule 54, the modes of procedure for attachment of the immobile property initiates or starts with issuing a prohibitory orders. They will issue the first prohibitory orders to the debtor and the public generally. This order will prevent the judgment debtor from transferring the property to himself or any. Who is the judgment debtor here? Plaintiff or defendant?
Either party, sir, against whom the order has been passed.
Generally, it's a defendant. Defendant is a judgment debtor, and decree holder is
Plaintiff.
plaintiff. From transferring, even a judgment debtor should not supposed to transfer the property to either to himself or anyone else or charging it. He could not even make it under charge also. I don't know how many people will not know the charge. Charge is different, motive is different. Am I right?
Yes, sir.
And when I was dealing, I think the Transfer of Property Act, I dealt in detail the charge. So either in the charging, the judgment debtor shall attend the court on the date decided for deciding the terms of the proclamation of the sale. Suppose if it is attached, on the day the judgment debtor should be there. Normally, for immovable property, 2 copies of the prohibitory orders are sufficient. But where the land is such that the revenue accrued from it is paid to the government, 3 copies of the prohibitory order is prepared. One for the judgment debtor, another for the decree holder, and the third one is
For the government.
For the government, because if there is any dues are there, like what you will pay for the land? Some cess? What do you pay
Tax,
it? Yes, some what type of the tax it is? It's a land tax. Can you say land revenue? You will say generally.
yes, sir.
Anyway, that whatever that may be the due of the government, that should be cleared. That's why 3 copies should be prepared. In order to make the attachment lawful, the particulars given in the schedule attached with the order should be matched to be exactly the same with the details given in the schedule of the property given in warrant. So, whatever the property subject matter would be there, that should be very much clearly written on. Suppose if he's having the 2 or 3 houses, and 2 houses are enough for the clearance of the debts, then it should be clearly mentioned so and so house worth so and so of a different direction, name, and etc. And that should be made for the sale. In case if he borrowed the money and paid it, of course, sale will be stopped. Am I right?
Yes, sir.
And that is the way. And it is not amount to defamation. Many people will gather over there. And what happening? No, that if the house is attached because he's a defaulter, there is he's a judgment debtor, and there's a decree is there, and he feel humiliated, and he again goes to somebody else and borrowed the money and paid the money. At that instance, he cannot make the case of the defamation. Is it clear? Say yes or no.
Yes, sir.
See, we have studied in the law of tort case law. He has taken the money from the bank, not bank actually. His due is there, land revenue due is there to the government, and the government has sent the Patwari or Patel at the time and to seize his property. At the time, the wife went and locked the house, and nothing is there outside the house. And amount is, of course, it's not that big amount, but the less amount only. But if the government official found he is having a gold ring in his ear, not ear, either ear or the nose. No, it is the ear only. So they called the goldsmith to remove the gold ring. By that time, some good Samaritan paid the amount to the government official, the due, and everybody disbursed. But he felt humiliated and he filed a case of the defamation against the government. The government said, if you have paid it, we did not do such a thing. And moreover, we called the goldsmith, and goldsmith did not take the earring to you. In case somebody will not pay it, definitely he will remove the earring from your ear. Am I right? So I don't know the name of the case law, but it is not amount to defamation. Is it clear? Say yes or no. Participants, are you
Yes, sir.
hearing me? Some problem is there. Are you hearing me?
Yes, sir.
Good. I appreciate.
Sir,
Furthermore,
one doubt.
yes, a little bit. I could not hear you because I saw there is no signals at the time when I was speaking. When I was speaking now, here the green mic will there and it will palpitate. So that gives the sense to me that you are hearing me. So now, furthermore, the warrant and the proprietary orders along with the copy shall be submitted to the Nazir. And here in the village there are people would be there. I don't know, Nazir is one of the superintendent, something like that. What is meant by Nazir? Anyone?
He is a court staff, sir, who will give attachment order, I think, sir.
But Sharishtedar?
Sir?
Sharishtedar.
That vocabulary is in the time of Mughals, sir. Not
Yes.
now.
Yeah, because some of the terms still continued over there. Sharishtedar means superintendent, something like that. Because it is he who decide how much the stamp duty should be paid. or the court fee should be paid. So here the Nazir is there. Nazir will then endorse the warrant and return it within a defined time before the court. Of course, he is the one person who take care of it. Where any person delegated by the Nazir completes the above mentioned work of attachment of the property. So it is a Nazir who will pass the order. Through him, it will go, but he will appoint the somebody else to execute such a warrant of attachment or sale also. Nazir completes the above mentioned work of the attachment of the property, a separate document stating how the day and hour at which he did such an act has to be properly attached. So the specific date would be there and time would be there where the attachment would be made later on. The open sale would be there. Am I right? Tender like
Yes, sir.
tender. So warrant of attachment of land, there is a drum beating charges. They will advertise it. Am I right?
Yes, sir. Paper publication will also
And
be there, sir.
nowadays there is no drum beating. It is only the paper notification would be there. In the conspicuous places, it will be pasted. And those who are interested in the land or property wants to buy it, let them come and buy it. And that is the way that we can make it out. Suppose for that one, the charges of the press also will be deducted. So any customary or usual practice will be carried out of the proclamation of the order, and the copy of it will be affixed on a conspicuous part of the property as well as on the court. So a permanent place where people could generally see the front yard and the public places and the court notice boards. So those are said to be the conspicuous parts of the where this notice will be pasted. After this, the reader has to be recorded a note stating the fact that all the required formalities dictated by the law to be followed have been complied with. Of course, whatever the rules and regulations will be followed over there for the attachment, and that will be followed. Later on, the sale would be made and the property would be sold, and the highest bidder will be given the chance to buy the property. Am I right?
Yes, sir.
So the presiding officer will then take the charge of ensuring its truthfulness. Of course, the court appointed a representative on behalf of the Nazir, as somebody will be sent by the court and he will be there and he will record all the proceedings. The court also has the obligations to make sure that all the requirements of the formalities for the legal attachment have complied with in order to prevent any sort of material irregularity as it might cause serious trouble and loss to the parties. So they will see that all formalities should be followed and then only the attachment and the sale would be undertaken. The civil court should also apply proper caution and care in the process of service of the warrants of attachment before they take any action concerning the property. So they should be very much careful before issuing the warranty of the attachment, and all the rules and regulation will be followed over there. Then only it will be served the warrant attachment. When the property is mobile property, which is not agricultural produce, then the attaching officer can seize the property and keep it in his custody. If it is a mobile property, the attaching officer keeps it in his custody. But on the other hand, if the property is seized is of a perishable nature, or the cost of keeping it is likely to exceed its value, the attaching officer can sell it immediately. Suppose the attaching officer are there. He attached the tomatoes. Can he keep for 1 month?
No, sir.
What will happen?
It will be destroyed, sir.
Don't use the word destroyed.
It will lose its value.
Not that you are making indirect way. There is a specific.
Perishable in nature, sir. It is.
That is perishable nature, I know it. The tomatoes are rotten, or tomatoes become putrid, or tomatoes become decayed. Which one is the appropriate word?
Rotten.
decayed, putrid. We can use it. Suppose if he doesn't know the particular word, we can say it damaged. Huh? Or it will be perished, or it will be rotten. మురిగిపోతాయి అంటారండి తెలుగులో. What do you say? What do you say? Tomatoes.
Decade, sir, maybe.
Yeah, you can use the word. What do you say in Telugu?
Pass on, sir.
Okay, it doesn't matter. You can use any word, but you can, suppose if they don't know these all terminology, you can say the tomatoes will be damaged or it is become totally perished. Actually, perished means it loses its value and it will be only be thrown as a garbage. Okay, let us see that. But on the other hand, if the property is seized of a such a, suppose if it is a, say about potatoes, it will be last longer. Am I right?
Yes, sir.
So if the attachment officer,
Rotten will be used for
yes,
rotten and putrid words terminology will be used for the purpose of which thing, sir?
because generally, if it is animate thing, we use certain words. For inanimate thing, we use certain words. Then for the fruits, better we can say, because we will come across that word in the Donegal versus Stevenson, the snail is there floating in the tumbler. So there we will say decayed snail, rotten snail, or putrid snail. These are three terminology anyone you can use it, because the snail is an insect and it is a carcass. So that particular word can be used over there. But in the potatoes and tomatoes, of course, potatoes it's last longer, so we need not to worry about that potatoes. But when you matter comes to the tomatoes, generally we use the word rotten. We can use the word rotten. Now I will show you that what tomatoes are rotten. Let me use it. Insufficient calcium tissue tomatoes and not tomatoes. Tipsy, how do you treat bottom or rotten tomatoes? How do you stop blossom not tomatoes? No. We can use tomatoes are rotten. That is generally the word we can use it. Let us see. Why is rotten tomatoes called rotten tomatoes? Yes, rotten can be used. Rotten tomato connects to the practice of the audience throwing the rotten tomatoes in a disapproval of the poor stage performance. Generally, when the person's performance is not good, people throw the eggs and rotten tomatoes. Am I right?
Yes, sir.
So they say rotten tomatoes. What do you rotten tomato means? Here they say when at least 60% of the review of the movie TV shows positive red tomatoes is displayed in the indicate the fresh status and green spallat tomatoes. Green is called spallat tomatoes. So when the less than 60% of the review for a movie TV shows are positive, a green spallat is displayed to indicate the rotten status. So we can use the rotten tomatoes. That's the appropriate word. Am I right?
Yes, sir.
Good. So decayed we can use for the insects. Okay, now we can, of course, there are some synonyms sometimes you can use, but appropriate word should be used. What I want to say. Is it clear?
Yes, sir.
So now, here, which are perishable nature, they are sold immediately, and the attachment, if the nature is not perishable like the potatoes, then it will last longer, then it will take the time, and they will make it out. Otherwise, the seizing officer, he can sell it immediately. So likely to its value of the attaching officer can sell it immediately, because if you keep it for a longer time, the value would be lessened. If the attachment officer fails to sell the such property by applying the every means, he can, at the instance of the judgment debtor or decree holder or anyone having an interest in such property, have it in the custody of the respectable person in the village or place where it has been attached. Naturally, if he delays it, it is a burden on him. Because the value which they are going to get it, they lose it. Because when it is become rotten. Is it clear?
Yes, sir.
Who will bear the loss? Naturally, it is an officer should have to take care of it and he should not make the delay. If you make the delay, the value will be lessened. Then is the carelessness on the part of the officer. Naturally, when such a thing would be there, officer will be negligent. Am I right?
Yes, sir.
Yes? Say yes or no.
Yes, sir.
So the custodian will later can be made liable for the inability. See, here clearly written. Who is the custodian? Officer. Will later can be made liable for the inability to produce such property before the court or for any loss or damage caused to it. So it is the responsibility of the officer. If it is a perishable nature, immediately he can sell it. If it is not perishable nature, bring to the notice of the court or in the custody of the court. So when the property is in agricultural produce, a copy of the warrant of the attachment can be affixed on the land on which such crops are grown. Suppose if it is agricultural land, after some time they will harvest it. At the time, the copy should be put it over there. Nobody could cut the harvest and cultivate the harvest or the plants. And at the time, if an officer comes and he will see that all the crop, agriculture produce would be collected and will sold in the auction. And where he produce has been cut and gathered on the threshing, treading floor or the fodder stack. I don't know what is threshing. Do you know what is threshing?
No, sir.
See here, threshing and treading, the fodder stack. See, when you make earlier, now the machine is there. It will cut it, only the paddy will be filled in the sacks. But before that one, the farmer used to cut it and keep it for dry, and afterwards they will take in bundle form and they will beat on the table. And after beating on the table, some of the paddy will not come out. So they will take the cows and bulls to treat it. బంతి కొట్టడం అంటారు దాంట్లో తెలుగులో. So they treat it. Afterward, they will take the grass, the hay, and they will make the bundle and it will be used as a fodder. Is it clear? Fodder అంటే చెప్పండి. What is fodder? If you know it, you tell me. If you don't know it, say pass on.
Pass on, sir.
Gaddi. Either vari gaddi or hay or green grass. Anything which can be eaten by the animals are called
Fodder.
fodder. Do you know at the time there is a fodder scam in the Bihar, Mulayam Singh Yadav? He is a Mulayam Singh Yadav or anybody? Fodder scam. Of course, sir, I did not born at the time. Okay, Lalu Prasad Yadav, it is there. Because I wrote an article, fodder scam. Okay, now let us see the next. Where the property to be attached is a negotiable interest, which is not within the custody of the public officer or deposited in the court, the process of attachment can be carried out through the actual seizure. Of course, the goods are there, we can attach it, I can seize it. Immobile property are there, we can make a fencing, or the court seal would be there, and there is a warrant will be posted on the conspicuous places, and it will be the custody of the court. The court will decide it when to sell it. Of course, Nazir will make all the efforts and see that the property will be sold, and the decree holder will be paid the money, and whatever the money would be left over there, it will be deposited in the judgment debtor's bank account. Is it clear?
Yes, sir.
Precept. I don't know how do you pronounce. Precept. Is it clear?
Precept. Yes, sir.
So the dictionary meaning of the word precept is a general rule intended to regulate behavior, a writ or a command. It is a general rule which should be followed or regulate behavior like a writ or a command. According to section 46, attachment can be made under the percept, under which an interim attachment is provided to the decree holder. Of course, interim means in the between. The section provides that the court which passed the order may, on the request of the decree holder, issue a precept to the court within whose jurisdiction the property of the judgment debtor is lying to be attached to any property specified in the precept. It's the interim relief. Am I right?
Yes, sir.
See, what are there first? Precept, decree, order, judgment. Is it not the sequence? On the day, S.R. Venunath made it clearer to us. The last one is
Precept, sir.
no judgment. Before it, here precept they have given, no. It is given generally interim relief like that. Interim attachment. See, it is given, see here. Interim attachment provided to the decree holder, to the plaintiff. And later on, order will be given or judgment will be given. Does a precept aim at preventing the alienation of the property? Why it is given? If not given, that judgment debtor will sell the property. Like seizing the accounts, seizing the bank account, so that he cannot transfer it. It is one of the thing, and that here in the attachment we can say precept. But in the injunction, temporary injunction. Am I right?
Yes, sir.
The beginning one, the first one. If not, that fellow will construct it. If the interim injunction is not given, temporary injunction, that fellow will construct it. Till the case is decided, either the temporary injunction will be what we say, it is vacated, or the temporary injunction will become a perpetual injunction. Am I right?
Yes, sir.
So it is a precept aims at preventing the alienation. Alienation means selling, either sale or gift, whatever it may be, the mode of transfer. Alienation of the property of the judgment debtor not located within the jurisdiction of the court which passed the decree. Suppose if it is not in the jurisdiction of the court, such a precept will be given over there so that he could not alienate it. So that is the precept. Now the garnish order, it is regarding the banks, money transaction, garnishi. Let us see that what is a garnishi. Rule 56 capital A to 56 capital I, Order 21, again committed a mistake. Order 21 outlines the procedure in case of garnishi order. In garnishi order, the decree holder, means plaintiff, seeks to reach the money or property of the judgment debtor in the hands of a third party. He will go, please stop the transaction. If the third party is bank. Suppose if the bank is there, he will go to the bank and ask him, sir, don't pass any transaction of this fellow, because he shows a court order. So a third party there, he will go and ask him. The decree holder seeks to reach the money or property to the judgment debtor in the hands of the third party. I mean, third party will hold it. Suppose if it is the judgment debtor and he will sell the property, he alienated the property, and the third party would be there, naturally he cannot take from there, and that is called garnish order. Then the third party may be ordered by the court to pay the judgment creditor. So third party will be act as the umpire, like an administrator. Are you following me? In the will,
Yes,
is
sir.
the administrator. What is the administrator? Is a masculine gender or a feminine gender? If you know, you
Masculine,
tell
sir.
me. What is the feminine gender? Administratrix. Please check it, the spelling. So then the third party may be ordered by the court to pay the judgment debtor the debt from him to the judgment debtor. This type of exchange is valid. So it goes to the third party. It is not in the hand of the it is not in the hand of the judgment debtor. And later on, if once paid it, then it goes to the judgment debtor possession. This type of exchange is valid. So here exchange from where to where? Exchange from where to where?
From
The
judgment
judgment
debtor to
debtor to the third party who is a garnishee. Once the transaction is over, again the garnishee will give the property to whom? Sir, decree holder. To whom he will give? Judgment debtor. Did you get my point?
yes, sir.
Why it is not the hands of the judgment debtor, you tell me? If it is in the hands of the judgment debtor, he will transfer and alienate the property. So the property will be given to the garnishee, a third person, by the court direction. And the third person holds the property and he will dispose the property, he alienate the property, he sell the property and give the money to the decree holder. And if any other property is left or money would be left, then it would be given to the judgment debtor. And this type of exchange is valid exchange because of the court order. That is called garnishee order. In the garnishee order, all the property would be, or the money would be in the hands of a garnishee, third person. Is it clear?
Yes, sir.
So, a garnishee is a person who is the debtor of the judgment debtor. See, he is a debtor of the judgment debtor. And he is the person who is under the obligation to pay his debt to the judgment debtor. So, he acted, whatever the debt of the judgment debtor would be there, he will clear it. Or to deliver any movable property to him, if it is left over the movable property, after paying the decree holder. Am I right?
Yes, sir.
So garnisher is the one whose favor the decree is passed, that is the decree holder, judgment creditor. He is the person who brings such a proceeding to reach judgment's debtor, money or property held by a third party. So it is an order given by the court. Now the property is that the garnishee, and the garnishee order would be there. Once the garnishee paid all the debts of the judgment debtor to the credit, to the decree holders, either may one or two or the rest of the movable or immovable property will be given back to the judgment debtor. Why? If he does not do so, the judgment debtor will alienate the property. Is it clear?
Yes, sir.
Good. See, when your credit card is lost, when your checkbook is lost, what do? Sir, I will go to
Generally,
the
we
police station and lodge a complaint. What do?
yes, sir. We lodge complaints, sir.
You go to the bank first and give an application to the manager stating that I lost my ATM card and I lost my checkbook. Please issue me stop the transactions and issue me a new ATM card and a checkbook. Of course, it is in the discretion of the bank to accept your plea. Suppose if you lost your certificates, original LLB or LLM or PhD certificates, at that instance, you have to approach to the ME-Seva, to the police station, and whose jurisdiction you lost your certificates. Are you following me?
Yes, sir.
How could you know it? My two daughters' original certificate, they lost it because of the changing the houses from here to there and there to there. And one daughter's, it is lost by the postal department. So I applied for the duplicates. That's why I know the whole procedure. Is it clear?
Yes, sir. In ME-Seva
course.
has to be applied, sir.
Yes, yes.
If original certificates are lost, in ME-Seva has to be applied, sir.
Yeah,
It
first
has
you have
be
to go to the
applied-
ME-Seva and you have to write
Yes,
an
sir.
application to the police station, particular police station, that to be loaded. Then the original application, then you take to the police station and you show to them. With the copies,
We have to apply from
with
the
the
education
copies of your
institute.
certificates also. You have to submit your original application at the respective police station after loading in the ME-Seva.
Okay, sir.
Then he will inquire it. So sometime he will clear it and he will write there how you lost it and so forth. And that ME-Seva certificate, you have to go to the affidavit and you make the affidavit again. What affidavit? Time is let in. What is the affidavit? In case I found the original, I will return this certificate to the respective authorities. The affidavit, you can make it. Then you go to the university, there is a prescribed form is there, and you take the form and apply whether Tatkal or ordinary, you apply it and affidavit, and this copy you should be submit it. Then after a due date, you will get your original. Of course, there is a written duplicate. Stamping is there. Either you want to take by personal, then you can request her not to post it. If not, through the registered post, it will come to your house. Is it clear?
Yes, sir.
So that is the procedure. See, if you miss my class, you miss many things, even though it is not in the course outline. Okay. Now let us see the determination of attachment. Determination means the status of the attachment at a particular time. In times of the cases where the property has been attached, but later on the court passes an order dismissing such an execution, the court will direct the status of the attachment. That is, whether the attachment will continue or discontinue to exist. Of course, here before the attachment, no, if we make clear, then attachment will not be there. Am I right?
Yes, sir.
If then the court fails to give clear direction, it is considered implied that the attachment has been seized. Of course, they say if the court fails to give clear direction, and it is considered implied that the attachment has been seized. Suppose the court will not interfere it, then automatically attachment will be seized. If the Nazir will not appoint any person, then automatically the attachment will be seized. Am I right? Suppose if you don't go, if somebody's wife will not go for the maintenance, naturally why the court will interfere and ask it? Suppose you go to the court and maintenance is given, and the husband is not giving the maintenance after the 2 years, and if she did not tap the doors of the court, then automatically the maintenance will be seized. Is it clear?
Yes, sir.
See, when you got injured today, can you go to the police station after 6 months?
No, sir.
Answer is, the court will ask it. Why we did not come to the police station? Sir, he told me that if I go to the police station, he will kill with the revolver. Okay. Then why you are coming now? Sir, he lost his revolver. That's why I am coming now. Naturally, there would be a reasonable ground would be there why you are not come to the court. If the court will be if the court will be convinced to condone the delay. Am I right?
Yes, sir.
See, I think it is viral in the WhatsApp. Is it the judgment is on the page number 46 in your written statement? Then the judge said, the advocate said, yeah. Then the judge told me, it is not the classroom or it is not the conversation with your friend. What do you have to say? Yes, my lordship, or yes, my judge, or whatever the terminology that you are using now. What is the terminology you use now in the lower court? Mr. Judge or
Your
Honor?
now sir can be pronounced sir.
Yeah, now can be sir. Yes, sir.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We live in a world full